everyone, and thank you so much for joining us today for this Legal Brokers and IQ Legal Training webinar. Today we'll be looking at residential leaseholds and in particular the recent and very topical Building Safety Act 2022. My name is Stephen Smith and I'm delighted to be joined as always by Ian Quayle and my colleague Robert Kelly, as well as our colleagues from Legal Brokers as well. Good morning to you all. Anyway, that's enough from me, so I'll now pass you on to Ian for the main part of today's presentation. Thanks, Ian.
Thank you, Stephen, and massive thank you to Legal Brokers and Stewart Title for inviting me along today. As I always say with sponsors, the legal profession owes them a huge debt of gratitude with regard to their assistance that they're providing, not only with regard to great products and great services, but allowing me to drone on from time to time about different topics. The Building Safety Act 2022 is the theme of today's presentation. And before we start, some words of warning. The Act is a vast piece of legislation that covers not just issues associated with fire safety, but building safety. The intention being that issues such as construction, risk of collapse, etc., are all encompassed within the Act. And all the Act is designed to do is to improve standards relating to building safety in all buildings, not just high-rise buildings, higher risk buildings, buildings of 11 meters in height or more, but all buildings. It also creates a new umbrella organization called the Building Safety Regulator that has a variety of different functions, including functions associated with building control, concerned with construction of new builds and refurbishment, imposing obligations on landlords described as responsible persons and leaseholders with regard to safety management whilst in occupation of the property. So it's not just duties and obligations being imposed on landlords, but leaseholders too. In addition to that, it has extended the limitation period under the Defective Premises Act, amended some additional legislation. So it's a huge bit of legislation, only part of which is currently enforced. What we're looking at today, in essence, is Section 117, Section 119, and Schedule 8, which impacts on leaseholders in that theoretically it provides protection for leaseholders with regard to a landlord's ability to transmit remediation costs into service charge. So that's what we're going to be looking at today, but it's important to understand and appreciate that the Act is far wider scope and significance than that. So as I mentioned on slide here, we've got the Building Safety Regulator, alterations to the Building Act, the creation of a concept of higher risk buildings, buildings in excess of 18 meters in height, other provisions about safety standards, etc., that apply to any buildings where there are 2 or more residential units within them. In addition to that, we've got other provisions about safety and standards in connection with buildings. And again, I repeat, this doesn't just simply apply to higher risk buildings or high-rise buildings. So someone sent me an email early this morning about lender's instructions. And the important thing to understand is that where a lender's instruction is asking you to consider the Building Safety Act 2022, you may think, well, that immediately only applies to buildings above 11 meters. It doesn't. It potentially applies, as I repeat, to any building where there are 2 or more residential units within it. I have been working with the government, talking to the government about the Act. The government concedes that the Act has a number of flaws, if you pardon the pun. In addition to that, they concede that further regulation is going to be required in connection with clarification. I'm currently working with Andrew Butler KC at Tanfield Chambers, 2 of his colleagues and a pupil at Tanfield Chambers who are spending most of their time looking at the Act. And so far, all we've managed to do is look at it from the perspective of acting for a buyer. We're currently working on what we should be saying and doing in connection with landlords, and that is probably a 20th of the Act, to be honest with you. So it is a moving feast, it is a imperfect feast, and it's a complex bit of legislation, as we're going to see. What I hope to do today is to create a route map for you that will enable you to think about acting for sellers and buyers. There are a number of caveats, there are a number of problems, there are a number of issues that you need to deal with in your retainer and in reporting on title. But I do think it is possible currently to act for a buyer in connection with a flat or apartment that's caught by the Act. The problem that I have is acting for lenders, and some of the lenders' instructions that you are receiving, in my view, would mean it would be impossible for you to act for a lender, thus impossible to act in a transaction. The government tells me that they are in regular dialogue with lenders, requiring lenders to amend their instructions so that the Act becomes workable, so that you can act. The final point I make before I go to the next slide is I do think if you are undertaking leasehold work at the moment, you should charge more for the work that you do. You are going to be required to look at more documents. You're going to be required to provide more explanation to clients relating to documents, and there is risk associated with this type of work at the moment, and you need to build in costs relating to those risks, as we'll see. So the Act is vast. Again, I've just showed you another slide with part 5 of the Act and other issues. So it is a huge piece of legislation that doesn't just impact on your work if acting for sellers or buyers. The Building Safety Act, as far as we're concerned, it provides the opportunity to protect leaseholders in connection with remediation of certain defects. So we need to look at what sort of defects we need to talk about and are covered within the Act. We need to look at what sort of buildings are protected by the Act and what sort of leases are protected by the Act. So we need to look at relevant defects, relevant buildings, and qualifying leases. We also need to explore the additional documentation that we're likely to see or receive as part of the conveyancing process and decipher to what extent we can rely on that documentation and what we ought to be doing with that documentation in connection with advice. So the first thing I want to touch on is the LPE1 form, which now, courtesy of its amendment as of January this year, includes additional questions. And one of the things that I'm often asked about is, can we rely on what a landlord is telling us in an LPE1? And the answer is potentially yes. If a landlord were to provide incorrect information with regard to an LPE1, that would be a misrepresentation, would also potentially be a criminal offence. Having said that, if you look at the ARMA website and guidance to landlords and managing agents with regard to LPE1s, all are encouraged to insert disclaimers in the response to an LPE1 question. And although ARMA is currently reviewing its guidance to practitioners, my view is that there will be again a recommendation that landlords insert disclaimers. There is government guidance with regard to landlord certificates and leaseholder deeds of certificate. There isn't guidance with regard to how landlords should be completing LPE1s, but what we can expect is the LPE1 to contain more information. It is likely to include a leaseholder deed of certificate where one has been produced by a relevant leaseholder and submitted to the landlord. It is likely to include a landlord certificate. The landlord certificate is in essence a document from the landlord verifying the landlord's financial status. Depending on that status, the landlord will either be in a situation where it is liable for remediation costs itself, or it will be able to transmit remediation costs into service charge, subject to what we've got to say about Schedule 8 in a moment or two. I've mentioned already that an LPE1 might contain disclaimers, which we need to look out for. It might also contain details of enforcement action. Enforcement action in this context I can subdivide into two areas. What action a landlord is taken against responsible persons for remediation costs, and also enforcement action that's being taken or could be taken in the future by the building safety regulator against landlords. Before I leave this slide, when we talk about enforcement action against third parties, I think it's important that we understand the ethos behind the Building Safety Act. One of the aims of the Building Safety Act is to ensure that where remediation works are necessary that generate cost, the person at fault relating to that remediation is liable for the remediation costs. So there is something called a cascade principle. That principle assumes that a landlord will pursue a claim against the contractor that did the work that now requires remediation. To that extent, the Defective Premises Act now has an extended limitation period of 30 years. Where that pursuit of the original contractor or contractors is exhausted, the landlord is entitled to recover in connection with a number of government remediation schemes. So that's the second tier of the cascade. Where that is exhausted without landlord receiving funds, then the landlord can, subject to the constraints of the Act, pursue leaseholders within service charge for remediation costs. A number of things flow from that then. First of all, it's important that a leaseholder or a buyer is made aware of what measures or steps are being taken by the landlord in connection with that cascade. So have we pursued claims against original contractors? Are we claiming or have we claimed in connection with government remediation schemes? Also, the landlord certificate should reveal to us what sort of remediation is being undertaken in connection with what works. So, in that regard, the landlord certificate can be important because it may be that landlords are incurring costs relating to remediation for work that they or their associates have undertaken. In which case, if we have a relevant building and a relevant lease, there will be the potential for the cost not to be transmitted into service charge or the cost to be capped or subject to ceiling. Where the remediation work reverts or requires work to be done in connection with cladding, then as long as we're dealing with a relevant building, whether we have a qualifying lease or not, the cladding cost cannot be transmitted into service charge. So the landlord certificate and the information in the LPE one is going to be important. With regard to the leaseholder deed of certificate, we're going to have a deep dive into that certificate before we finish today to determine what we should be doing if acting for a seller or a buyer where a leaseholder deed of certificate is produced. The important thing to understand, however, is that where a leaseholder deed of certificate should be produced and isn't, then the position is that the lease will not be a qualifying lease and will not be protected. Equally, if a landlord certificate should be produced and isn't produced, then by default, any leaseholder within the building, assuming it is a relevant building, will be protected under the Act. So in some respects, a landlord that does nothing and doesn't produce a certificate is good news if you're acting for a buyer, because you can safely say, provided this is a relevant building, that the Act will apply. Some landlords are so concerned about the costs that are incurred in production of a landlord certificate, the amount of information that needs to be produced within the certificate, that on balance, it is easier, cheaper, and more cost effective simply to pay remediation costs, knowing that they can be recovered, they can't be recovered rather from leaseholders, rather than producing a landlord certificate in the hope that the costs can be recovered. So certainly there's been a lot of consternation amongst landlords about the amount of time and energy that needs to be spent to produce information for the landlord certificate, and the fact that they are in essence producing information which may well be commercially sensitive, and therefore some landlords are saying, well, we'll just not bother, in which case the leases will be deemed to be protected under the Act and we can't recover remediation costs from our leaseholders. The Building Safety Act creates problems for two reasons. Firstly, it's complex. Secondly, because not all of it is in force. So you may have been aware that as of April, a responsible person in connection with a building that's more than 18 meters in height must now register that building with the building safety regulator. The problem that we have is that the building safety regulator is not yet operational, and therefore registration is required with the health and safety executive. That registration process must take place before the end of October. So where you have a building, it's always worth inquiring whether or not the building has been registered. If it is registered, then we can assume it's more than 18 meters in height. If it's more than 18 meters in height, it follows it's higher than 11 meters, and therefore potentially Schedule 8 could apply to it, meaning that a landlord certificate and a leaseholder deed of certificate are required, and also meaning that, subject to what we've got to say later in this presentation, our lease is protected under the Act. I mentioned on slide fire safety regulations and the fire safety legislation. Some practitioners have said to me, well, because the Building Safety Act applies, the Fire Safety Act and fire safety regulations don't apply. That's not true. The fire safety regime is ancillary to the building safety regime. The building safety regime incorporates construction issues and risk of collapse issues that clearly fire safety has nothing to do with. But fire safety legislation and regulations could require landlords to undertake remediation work, and that remediation work can fall within the scope of the 2022 Act and all that I'm going to say that follows. I think it's important when we're taking instructions from buyers in our retainer that we exclude explanation or advice relating to fire safety regulations and legislation. I think it's important that we tell clients that the property that they're acquiring will be subject to that legislation and regulation, and that landlords will be responsible for compliance. The building safety regulator ultimately will be responsible for ensuring that responsible persons adhere to the legislation and regulation, but that there could be works that need to be done to bring buildings up to standard, or for repairs or works to be done courtesy of inspection by building safety regulator, HSE and/or others, that requires remediation work to be done, that then falls within the scope of the Act and the points that we're going to make later. Other problems. I mentioned lenders' instructions. Well, what about risk? Let's just drill down on this point for a minute or two, and let's see why conveyancers are terrified about acting. What could possibly go wrong if you're acting for me and I'm purchasing a flat in a 15-story tower block that exceeds 18 meters in height? Well, all right, let's assume this is a relevant building, and let's assume that I'm buying a qualifying lease. You're my conveyancer. You could first of all bravely suggest to me that the Building Safety Act applies to my lease. If you do that, and if I am moderately knowledgeable or risk averse, I may be aware that because of that, I know that certain remediation costs relating to that building cannot be transmitted into service charge. Cladding and recladding issues. Works that need remediation that were works that were done by the landlord or the landlord's associate are out of the picture. They can't hurt me or they can't bite me going forward. But other remediation costs could, but they are now, if I'm protected under the Act, subject to a cap. Assuming my imaginary flat is outside of Greater London, the cap will be £10,000. Assuming the flat is in Greater London, the cap would be £15,000. The cap is not automatically applicable, as we'll see in a moment or two. But the comfort that I've got is that there isn't a steam train coming down the track at me at some point in the future that wipes me out. We're not going to see the post-Grenfell decladding, recladding debacle that leaves me with a £250,000 contribution to service charge that exceeds the value of my flat or apartment, or that means that the only option I've got is to petition for my own bankruptcy. So the idea of the Building Safety Act is that I buy with comfort. If I buy a property that isn't protected under the Act, my vulnerability is that there is remediation work that the landlord undertakes that the landlord can easily, quickly and swiftly transmit into service charge, and that I'm liable for it. So that's the risk. And your risk is that I sustain loss as a consequence. So had I been protected under the Building Safety Act, I wouldn't be met with £100,000 worth of service charge costs in 2024. The other side of the coin is that if you tell me the Act doesn't apply, then when I am faced with £100,000 worth of service charge costs, I meet it or borrow money or beg and steal to pay for it. And then I find out at a later date that in fact the Act would have applied, and had I known it, there were steps and measures that I could have taken to defeat the claim that the landlord brought relating to that service charge cost. The bigger picture with regard to the Act is, because the Building Safety Act, if we look in the sort of the bigger picture, the completeness of the Act, I think will lead to increases in service charge costs in any event, whether I'm protected or not. A landlord is under a greater duty and responsibility with regard to assessment of risk, with regard to management of risk concerning building safety. The building safety regulator is going to manage or supervise building safety issues and require leaseholders and landlords to take more care with regard to building safety that will increase service charge costs across the board, and those service charge costs will be recoverable by landlords within service charge, looking at the existing service charge provisions within leases. So that's the risk. What about landlords, managing agents and management companies? Well, I think there's risk if you're advising any of those entities, on the basis that it is important to understand that the Act could apply, which would mean that there are caps or ceilings relating to service charge that might require consideration when thinking about incurring expense. And where the Act doesn't apply, a landlord or other responsible person may have more freedom with regard to recovery of cost. So I think there's risk or vulnerability when acting for a buyer, potential liability when acting for a seller, and probably more liability or more risk when advising landlords. As far as the Building Safety Act is concerned, what we've got to do is identify relevant buildings and qualifying leases and relevant defects. Because if we can do that, then we've got the potential safety net that the Building Safety Act generates. So let's talk about relevant defects to start with. Defined under the Act under Schedule 8. The key here is that the Act applies and protects the leaseholder from remediation costs for relevant defects, and so is valuable as a protection to current leaseholder and future leaseholders. And there we see the definition of a relevant defect. Defects as a result of works undertaken in the last 30 years and causing a building safety risk, a risk to the safety of people in or about the building arising from the spread of fire or collapse. So we're not just talking about risk to leaseholders. We're talking about risk relating to anyone in or about the building, contractors, postmen, visitors, and everyone else. And significantly, the Act is not concerned with defects limited to fire safety. And so whilst fire safety and fire safety remediation work are going to be a major issue, and particularly at the sort of height of people's minds and concerns, other issues with regard to the standard of construction also have the potential to be relevant defects. The next thing to talk about is what are relevant buildings. And the important thing to understand here is a relevant building under Schedule 8 is different to a relevant building under the Act. The Act itself would apply to any building where there's 2 or more residential units within it. But with regard to Schedule 8, if we look at a relevant building, we talk about a self-contained building or self-contained part of a building containing at least 2 dwellings that's either 11 meters high or contains 5 stories. Our first problem as a conveyancer is how on earth can we determine the height of a building or whether it contains 5 stories or not? Well, let's just look at this. Might a landlord tell us? Answer yes. Remember that if the building is more than 18 meters in height, the landlord should be thinking about registering it with HSE. So that helps us. Would the seller or leaseholder be able to confirm the height of the building? In my view, definitely not, and not a reliable resource. Would a surveyor or valuer tell us about the height or the number of stories of a flat or apartment? Now, in talking to surveyors, the answer is they're not going to commit to that for fear of potential liability. One firm of surveyor, has said that they would, for an additional fee, verify height. So that might be something worth exploring. But I think the thing that we've got to do is we've got to say it's not within your remit to make a determination as to the height or number of stories of a property that your client is buying. Because if you get it wrong, then the position is that what you thought was a relevant building for the purposes of the Act is not a relevant building. The next thing that we've got to determine is, are we dealing with a qualifying lease? So here we've got to look at section 117.2 of the Act, which makes a number of requirements. Some of those requirements you as a conveyancer can meet and can verify. So we need a long lease of a single dwelling in a relevant building. We have the lease containing provision generating liability for a leaseholder to pay service charge. And we've got a requirement that the lease was granted before the 14th of February 2022. So in looking at the lease, I think a reasonable conveyancer can assess whether criteria A, B, and C are met. The problem that I have with section 117.2 is 117.2D, which requires us at the qualifying time to state whether the dwelling was the current leaseholder's only or principal home, a relevant tenant didn't own any other dwelling in the United Kingdom. I don't know why we've got that section in the Act, because then we've got D3, a relevant tenant owned no more than 2 dwellings in the United Kingdom, apart from their interest under the lease. So let's just look at D for a moment. The producer of a leaseholder deed of certificate is required to confirm the lease is a qualifying lease. Where the person producing the certificate was the owner at the 14th of February, he or she will be able to determine that this was their only or principal home. They will also be aware of whether or not they owned no more than 2 dwellings in the United Kingdom, apart from their interest under this lease. In other words, 3 units. So, all right, you might have someone with a buy-to-let investment portfolio of 14 properties spread across England, Wales, and Scotland, who thinks, if I disclose the existence of that ownership, I don't meet criteria D, and therefore I exclude my lease from being a qualifying lease and the protection of the Act. So what I'm going to do is hide the fact that I have an investment portfolio of buy-to-let properties. So I'm going to produce a certificate confirming 117.2 D1, and I'm not going to disclose what else I've got. In doing that, the leaseholder has made a statement that they own a qualifying lease that theoretically affords protection. If a landlord down the line is met with a huge remediation cost and is looking to see whether current leaseholders will be protected or not, it's not beyond the realm of possibility of a landlord investigating who produced the leaseholder deed of certificate, finding out that the person that produced it has lied with regard to the form, and then says the leaseholder deed of certificate is defective. This isn't a qualifying lease. Sorry, this wasn't a qualifying lease, and so isn't a qualifying lease. The other problem that you've got is, let's assume that you've bought the flat after the 14th of February 2022. So you completed your purchase on the 1st of October 2022. You're now selling your flat to me. You are required to produce a leaseholder deed of certificate that states the position of ownership of that flat of the 14th of February 2022. Now, how on earth are you going to know that the person that was the relevant tenant at that time satisfied criteria D1 and failed to meet the criteria in D3? So the problem that I've got is that a leaseholder deed of certificate requires self-certification in connection with 117.2D if the seller was the leaseholder as of the 14th of February, and where the leaseholder was not the owner of the property at the 14th of February 2022, we've got a situation where they're guessing or carrying out investigation to determine the status of the relevant tenant. That's my problem. And my problem is compounded by lenders that are saying that I am required as a conveyancer to verify the information in a leaseholder deed of certificate. There is a short circuit with regard to 117.2D that we're going to look at in a moment or two. Before we do that, I just want to talk about the limitations on service charge that Schedule 8 generates. First of all, if we're protected under the Act, if a landlord or associate is responsible for a relevant defect, they can't incorporate it into service charge. If we have a flat in a relevant building, whether we have a qualifying lease or not, the landlord cannot include costs associated with cladding or decladding. Provided the landlord meets the contribution condition, a statement as to its financial status, the landlord could be wholly responsible for remediation costs. Where the lease is below a certain value, I think it's £315,000 from memory outside of Greater London, again, there are limits on the amount of service charge that can be included relating to remediation. If the service charge exceeds a permitted maximum, £10,000 outside of Greater London, £15,000 per minute within London, where the service charge exceeds a permitted maximum, the excess has to be the responsibility of the landlord. I've mentioned cladding remediation. Legal or professional services may not be recovered by way of service charge, where those legal or professional services relate to actions being taken by the building safety regulator or the HSE with regard to landlords' non-compliance with the Building Safety Act or other regulation. A number of things that I think are important here. The Act specifies that costs which are not to be regarded as service charge in paragraph 10 of Schedule 8, and this last point I think is important. Let's assume we have a block of flats that are 10 apartments in the block. 5 of the leaseholders have qualifying leases. The other 5 do not. We have a relevant building, so the 5 that have qualifying leases are protected under the Act, meaning that costs that are limitations on service charge under Schedule 8 are not recoverable from the protected leaseholders, if I can call them that. Can the landlord shift all those irrecoverable costs from protected leaseholders onto unprotected leaseholders? Answer, no. The position is that the unprotected leaseholder would not have the cap or ceiling. The unprotected leaseholder would be liable for some costs, but couldn't be liable for cladding remediation costs in any event. So landlords are left with irrecoverable costs, not costs that are irrecoverable from protected leaseholders that are now recoverable for unprotected. In other words, if you're paying a 20th of the service charge and you're unprotected, you will pay a 20th of the service charge. Your protected colleague or neighbour might be paying less, but you're not going to be burdened by that which is irrecoverable. I think that's an important point to note. The other important point to note is Schedule 8, paragraph 13. So far, what I've created for you is a headache to say a leaseholder deed of certificate can't be relied upon because it's self-certification, and there may be an incentive on the person producing it to state that they don't own more than 3 properties in the United Kingdom. And therefore, there is a risk that the person producing the certificate lies to fall within the scope of the Act, or that a subsequent buyer from the leaseholder who owned as of the 14th of February doesn't know and simply gets it wrong. What we've got in Schedule 8, paragraph 3 is a route to avoid the need to comply with condition D. So as long as we meet the long lease, the lease that was granted before the 14th of February, that lease that contains a service charge provision under section 119(2), as long as we meet that, then as long as the landlord has not taken the steps that are prescribed under Schedule 8, paragraph 13, by default, we have a qualifying lease and happy days. So what must the landlord do to defeat our circumnavigation of condition D? Well, look what I've highlighted here. A lease is treated for the purposes of this schedule as a qualifying lease unless the landlord under the lease has taken all reasonable steps and prescribed steps prescribed under the Act to obtain a qualifying deed of certificate from a tenant under the lease, and no such certificate has been provided. So if I have evidence that shows the landlord hasn't taken reasonable steps or prescribed steps to obtain a leaseholder deed of certificate and hasn't got one, then I don't have to worry about condition D. So, all right, Ian, what does that mean? It means this, quite simply. If I can show that the landlord hasn't taken steps to get a qualifying deed of certificate and hasn't got a leaseholder deed of certificate, I don't have to worry about the leaseholder deed of certificate being defective with regard to condition D. I can override it by this presumption. The obvious point, don't ask a landlord if he has asked for a leaseholder deed of certificate, because if you do, and the landlord knows what he's doing, he says, aha, I better ask for it, because if I do, I scupper the buyer's attempt to rely on the presumption that means he doesn't have to rely on condition D. Let's move on. Where are we going to get that information that tells us the presumption applies or not? Well, it's important to see what the landlord says in LPE 1, and it's important to see what the leaseholder says with regard to the TA forms. But where we can show that the landlord doesn't have a deed of certificate and hasn't asked for one, we escape the formalities of para D in connection with the leaseholder deed of certificate. So remember, the LP1 contains additional questions. There's a new form as of January. Make sure you've got that and that has been utilized, and scrutinize it to see what the landlord is saying in connection with the leaseholder deed of certificate or inquiries being made of the leaseholder for its production. Again, the leaseholder deed of certificate provides a record of ownership and occupation as of the 14th of February and is self-certification. You can't rely as a buyer on that information being accurate. You know, I've seen firms saying, well, can we ask for warranties, etc.? Well, again, dangerous. As I explained, with regards to the section 119 A to C conditions, checking the lease will provide you with that information, but ownership or occupation question is a tricky one. I know some firms were saying to me, should we instruct an inquiry agent to verify that the producer of the leaseholder deed of certificate has told the truth with regard to his ownership and occupation of this flat and others? Might be a route to take, but again, high risk and expensive exercise. A leaseholder deed of certificate is important. The significance is that it generates a cut-off point. Leaseholder deeds of certificate required for leases before 14th of February. After 14th of February, the lease is not a qualifying lease, and therefore a leaseholder deed of certificate is not required. A question that was put to me yesterday: what happens if the leaseholder was alive at the 14th of February 2022 and then has now died? Could a next of kin or an executor produce the deed of certificate? I think the answer to that is yes. As far as the deed of certificate is concerned, does it just apply for the current producer of the certificate? No, it provides a badge of honor, as it were, for subsequent owners. So if this deed of certificate is valid and legitimate, and if we've got a relevant building, then we're protected under the Act. The presumption is so important. And the thing that worries me about the presumption is that a lot of practitioners are not aware of its existence. And the other thing that worries me is that if you start asking landlords to produce leaseholder deeds of certificate by way of additional inquiries, etc., if the landlord switched on, he spots this and makes reasonable efforts or prescribes steps to obtain the deed of certificate. And if he doesn't get it, he scuppers you. So you do need to check if a landlord has complied with Schedule 8, Para 13, not by asking the landlord directly. Landlord certificates are required where a landlord is transmitting remediation costs into service charge, or where a leaseholder requests it or demands it, or where a leaseholder is selling a flat, or where a service charge demand is made relating to remedial work. Where the building is a relevant building and where the landlord is required to produce a certificate but fails to do so, then the leaseholders in that building are protected under the Act. So there's a draconian sanction, a practical sanction available to a landlord who fails to produce it. I repeat the point that I made a little earlier, that some landlords are saying the cost of producing the certificate, the information that we're putting into the public domain, is so sensitive that it's not worth our while. So you might find a situation where a landlord is just saying, I'm not going to produce it. If that is the case, then it won't necessarily block the transaction and will, to an extent, provide your client with protection by default. As far as surveyors are concerned, I think the first point to note and the first thing to state is that with regard to buildings that are subject to the Building Safety Act, more than ever, we should be encouraging our clients, or indeed insisting that our clients obtain a level 3 survey, the best survey that can be afforded. It's important to check the level 3 survey and valuation to assess whether a surveyor or valuer has highlighted any remediation issues or any issues that could potentially be a breach of the Building Safety Act fire safety legislation or regulations. A surveyor or valuer is unlikely in the survey or valuation that you're going to receive now to make any comment about the Act itself and whether the landlord is fully compliant or not. Further, I don't think the survey or valuation is going to volunteer information to you about whether the building is a relevant building and the lease a qualifying lease. I think it will be necessary to extract information if it's volunteered within the survey or valuation report, or to ask the surveyor or valuer about it. One firm of surveyors is saying to me that they will, as for payment of additional fee, verify height. But other than that, I don't think surveyors or valuers are going to help us. The RICS guidance, professional standard for valuation, which was revised on the 6th of December, highlights that surveyors should limit the retainer to exclude explanation concerning fire safety issues generated by survey or valuation. So I think surveyors are wise to the fact that they potentially could be in the firing line if they get something wrong with regard to fire safety, and I think it also follows in connection with building safety. Lenders, I think, have been quite cute. Government has leaned on lenders to say we have a problem with high-rise flats and apartments and fire safety issues and service charge issues. We would like you to encourage lending. We want you to open your branch doors to borrowers who want to buy flats and apartments. We want to kickstart the market. And lenders immediately said, yeah, we're happy to oblige. But what lenders have done is been quite cute. As usual, with regard to risk, what lenders are for saying is we're going to be relying on conveyancers to assist us to confirm that the property that we're lending on is within a relevant building and is subject to a qualifying lease. They could have imposed that obligation on their valuers, but they haven't. They've put it on you and I. Which leads me to say two things. One, whilst I'm moderately comfortable about acting for a buyer, I am very uncomfortable about acting for the majority of lenders. And certainly lenders that are asking me to verify information that's produced by landlord or by seller leaseholder, that instruction, I think, is impossible to comply with. Government says, and to be fair to government, in my last meeting, they told me that they were meeting with lenders the next day, and you would see movement from Barclays and Nationwide as a consequence. True to their word, that has occurred, but I'm still worried about anyone that's asking you to verify information contained within documentation produced by landlord or leaseholder in the context of the Act. Because I think you can't provide that verification, or you could, but the exercise in verification would be so expensive and so time consuming as to be entirely uneconomic and unworthwhile. So whilst I can provide you with a roadmap that I think enables you to act for buyers and sellers, where there's a lender involved, you need to check instruction. And important point, check instruction on receipt of instruction, and then, as is required by CQS, check again before you exchange. Lenders' instructions are changing. Government advice and government persuasion of lenders is constant at the moment, as is the government's attitude to the legislation and changes relating to it. So again, you've got to be on your toes just to make sure you're up to date with changes that are occurring. I mentioned remediation schemes and I mentioned the cascade principle. I thought it wise just to mention what those three schemes are. As to what funding is sitting on those schemes at the moment, I can't tell you, but I can tell you that the landlord, in the landlord certificate, ancillary information should be telling leaseholders about whether claims have been made and as to the progress relating to those claims. I want to talk a little bit about fire regulation because it's still an issue, and the Fire Safety Act 2021 remains good law. Note this applies to all multi-occupied residential buildings containing 2 or more domestic premises. So there's overlap between the Fire Safety Act and the Building Safety Act. And the Fire Safety Act requires responsible persons to assess, manage and reduce fire risks. So there could be remediation work in there that ultimately is transmitted into service charge regulated by the Building Safety Act. So I do think it's important that clients understand that we can't advise or explain or provide guidance with regard to compliance or otherwise with the Fire Safety Act, but where there is non-compliance, there is a risk that remediation cost is incurred that's transmitted into service charge. I think we should be doing that in any event, whether a building is a relevant building for the purpose of the Act or otherwise. The Fire Safety England regulations became law on 23rd of January 2023 and are slightly different in that they apply to multi-occupied residential buildings containing 2 or more domestic premises, but those domestic premises must share common parts. And what you have here are regulations that apply to all buildings that meet that criteria. There are additional criteria for buildings over 11 metres or 5 stories in height, and additional requirements for buildings over 18 metres or 7 stories in height. So it's absolutely essential that we understand and appreciate that there could be breaches of the Fire Safety England regulations in buildings that are less than 11 metres in height, where there are costs that are incurred that can be transmitted into service charge, to which Schedule 8 does not apply. The question that I've got with regard to the fire safety regulations and the Fire Safety Act is who's going to check whether a building is compliant or not. There we go back to our friend, the building safety regulator, I think, who is going to have that responsibility, who is going to ask, I think, for responsible persons, landlords, to confirm that audits have been undertaken and that there is or isn't compliance, and that remediation work is undertaken where non-compliance is evident. The other thing that worries me is that if there is non-compliance with the Act or regulations, could that invalidate insurance cover? And what happens about breaches or sanctions relating to the regulations? Where there is enforcement action taken by the regulator, the landlord cannot transmit those costs into service charge. The Act creates building safety charges, which are a sort of special category of safety of service charge. And the Act specifically mentions that where landlords are incurring costs due to non-compliance or due to enforcement action being taken by the building safety regulator or others, that cost can't be transmitted to leaseholders. At the end of the day, it's not the leaseholder's fault, seems to be the ethos behind it. So let's start having a look at some transactional issues. Can we act for a seller in connection with a flat or apartment that is potentially covered by the Act? I think the answer to that question is yes, we can, as long as in connection with a leaseholder deed of certificate, if that is going to be produced by the seller, we adopt exactly the same strategy as we would with the seller completing TA forms. The seller is completing the leaseholder deed of certificate on the basis of information that the leaseholder has, and that we're not providing any advice or assistance with regard to its completion. Nor can we be expected as a conveyancer or solicitor for the seller to give any warranties to the buyer as to the accuracy of the information it contains. I think if we're acting for a seller, we are likely to receive more information or documentation from the landlord that will need to be transmitted to the buyer's conveyancer. There is an additional cost, in my view, with regards to that additional documentation. As far as the leaseholder is concerned, the leaseholder can ask the landlord for a landlord certificate. The landlord is required to produce it, I think, within 5 working days. That will be quite an expensive and laborious exercise for the landlord. The landlord can't transmit that cost to the leaseholder's seller. If a landlord doesn't produce a certificate on request, then the lease, if it's within a relevant building, will be protected under the Act by default. Where the leaseholder deed of certificate has not been requested by the landlord and hasn't been produced to the landlord, that potentially will afford protection to the buyer because of the presumption that we looked at relevant to section 119 subsection 2 and paragraph 13 of schedule 8. So if we've got a leaseholder deed of certificate that's produced to the buyer, but the landlord hasn't seen it, then to an extent there's some protection courtesy of that presumption. I think if we're acting for a seller, we should warn the seller that where they've incurred service charge costs relating to previous remediation, they might be able to recover those costs. And I think this last point on slide is important. The seller client should be advised about the significance of making sure that the information in the leaseholder deed of certificate is correct and the potential redress if the information is not, similar to what we're saying in the TA forms presently. If we're acting for the buyer, sorry, I'll just go back to this slide. If we're acting for a buyer, I think it's important that we are meticulous in how we scope the retainer, so the client understands that we're not giving any advice or explanation concerning Fire Safety Act or fire safety regulation. We're going to provide the client with general information about the Building Safety Act, but we're probably not going to be able to commit one way or the other as to whether the Act applies. I think as far as the client buyer is concerned, he or she requires advice relating to service charge in the following terms. One, where historical service charge accounts have been produced, they are not indicators as to what the service charge will be going forward. There could be remediation costs that are applicable and incorporated within service charge that the buyer is going to be liable for. I always say to clients in a leasehold transaction, you are committing contractually to an unascertainable liability. In essence, that's what being liable for service charge is. I would explain to a buyer client that there is statutory protection relating to service charge in the form of the Landlord and Tenant Act 1985, which specifies that service charge is only payable insofar as the service charge is reasonable. There is protection to the buyer under the Commonwealth Leasehold Reform Act 2002 on the basis that the leaseholder would be obliged to be consulted with regard to service charge costs. If consultation does not occur, then service charge cost is capped at £250 per item or £200 per annum per item, depending on whether or not the service charge is of an ongoing nature. Sorry, the cost is of an ongoing nature. So I'd advise clients about both of those measures. In addition to that, where the lease enables the landlord to borrow money, I would say that that again is potential protection where borrowing money is permitted for unusual items of outlay. I would also advise a client if the lease enabled the landlord to borrow money to meet unusual items of outlay. But with regard to the Act itself, I would be cautious and say to the client that it is impossible to determine definitely that the lease is within or without the scope of the Act. I think all we can do under the Building Safety Act is what we're obliged to do in connection with all aspects of due diligence other than title, is simply to highlight risk. We are unable to quantify or identify the extent of the risk. Just tell the client there is a risk relating to liability for remediation cost, the risk of that cost being transmitted into service charge, the risk of additional service charge costs being incurred by landlords that are recoverable relating to compliance with the Building Safety Act. With general information to the client, we're telling the client that if the Act does apply, there is the potential for protection. I think that's the route we take, and that enables us to act. I think when you're acting for sellers, to make sellers aware of remediation orders and remediation contribution orders, and I think it's possibly wise to tell buyers about those rights of redress in any event in case of dispute with landlords going forward. So problems. Can a buyer or a conveyancer rely on a landlord certificate or leaseholder deed of certificate? Answer, probably not. You can't rely definitely on that information. Is the protection of the Building Safety Act 2022 extensive? It isn't extensive. It only applies with regard to service charge in connection with relevant buildings and qualifying leases. Other aspects of the Act will apply to all buildings that contain 2 or more residential units. And the Act is being introduced on a piecemeal basis, so you've got to keep ahead of it. When is the Act not affording protection? New leases. Leases where landlords are the freeholder or own the reversionary interest after collective enfranchisement. The Act would also not apply in situations where there's a lease extension on the basis that the deemed surrender and regrant, because you've got a new lease. So you'd have a situation where the old lease would be protected, the new lease wouldn't be. When I asked the government about this, what they said was, why can't the parties include contractual provision that the Act still applies? And of course, the problem there is no landlord worth their salt is going to say, yeah, I'm happy that the Building Safety Act 2022 applies to the new lease. Why would you? So it's important to understand that we need to check that the position relating to the application of the Act, but we're frequently unable to determine whether it applies or not. We can say with new leases it doesn't apply. We can say where we have leaseholders that are collectively enfranchised. If a building or lease is not a relevant building, then the Act doesn't apply. If the lease is not a qualifying lease, then the position is that that flat or apartment is not protected. If a leaseholder doesn't provide a leaseholder deed of certificate, the lease is not a qualifying lease and is not protected. So I want to finish. Does the Act increase the risk of leaseholder insolvency? I don't think it does. It decreases it. Does it increase the risk of landlord insolvency? I think the government hasn't thought about this, and the answer to that is yes, it does, which then generates further problems down the line. What I'm going to do is stop because I'm conscious of overrunning.
Ian, just a quick question that's come through from Amanda. Amanda asked, I think this relates right to the beginning of the webinar actually, but how does the legislation affect lower rise buildings, and is there a duty to ensure that it is compliant?
Yeah, well, great question, Amanda. It involves assessment of fire risk, involves assessment of risk relating to construction, imposes obligations on both landlords and leaseholders to be aware of risk, to report risk to one another, and to report risk to the building safety regulator. So there are additional duties and responsibilities that the Act creates in connection with low-rise buildings that you wouldn't think were covered by the Act. A lot of practitioners think it's only if we're 11 meters or 5 stories high that we've got issues. No, the Act applies across the board. The fire safety regulations and Fire Safety Act apply across the board too. So great question, Amanda. It's a question of being aware of the application of the Act in connection with any building that contains 2 or more residential units.
Yeah,
that's what
thank you. I am conscious of time myself, Ian, so I think that there don't appear to be any questions, so we will wrap it up there. So thank you, Ian, and thank you for everyone for attending today's session, and thank you to Legal Brokers as well. So that just leaves me to say thank you again, and on behalf of Legal Brokers, Stewart and Ian Quayle, thank you for joining us today, and have a great rest of your day. Thanks everyone, goodbye.